We've got a heck of a show for you today. If any of you have not signed up for Law Conference of Champions, I'll just spend this 1 minute here ahead of time promoting Law Conference of Champions. We do have I think we've got like 5 seats left. So it's basically sold out. It will be sold out by the time the show kicks off. But there's like 5 seats. If you want a seat, technically you can still get one. But the virtual option is available and it's awesome. 3 cameras. And it's a really, really good option. And that's available as well. So feel free to get yourselves the tickets at lawconferenceofchampions.com or shoot me an email. Okay, we've got people kind of pouring in. So let's get started. Really, really excited for this one today. It is a little bit different than what we usually do. I'm gonna be honest with you. This was all John's doing. So John Barbret, I'm gonna have him introduce himself here in a second. He's a board member with REACH, Responsible Enterprises Against Consumer Harassment. Hopefully you folks all know about that trade organization, which I serve as the president of. And our last member meeting, we have these monthly member meetings and we always have fantastic content. And at the last member meeting, John had put together a deck and was going through it with the membership on these trends of abusive lawsuits, these quiet hour cases and some other cases that we're going to talk about here, demonstrating just how manipulative and abusive and frivolous these things really are. And I thought, I mean, one, this is amazing content for Reach membership, but man, this is just so good. And as you're about to find out, the work that John put into this is so painstaking that we just had to make it public. Like it couldn't just be a members only thing. Although obviously there's a ton of benefits to membership, and there are obviously a lot of educational opportunities that are only open to members. This one was so incredible that I just felt like we had to have a webinar, walk it through, have Queenie join and myself kind of provide some analysis. I really sincerely think you're going to enjoy this. It's very different than webinars that we've done in the past, but I think you're going to love it. Before we dive in, though, you all know me. I'm Eric Troutman. I'm the czar. Let's introduce ourselves. Queenie, we'll start with you, and then we'll have John introduce himself as well.
Hi, everyone. For those of you who don't know me, I'm Queenie of TCPA World and partner here at Troutman Amin, LLP.
And her name is Puja.
Queenie.
John, yeah, go ahead.
Hi, I'm John, or JB if you prefer. I'm a director of TCPA Marketing Compliance at Americor. I'm also a board member of REACH. I have a flair for data. I grew up in IT, if you will, and then I migrated my career over to the legal compliance side of the business. So I've lived in both worlds, and so I like to make data-driven decisions, and so that's why I compiled what I have today. And I'm thankful for everybody for joining, and thank you, Eric and Puja, for letting me talk about abusive TCPA litigation.
So as you can tell, John is just amazing. He's a super nerd, and he's also a super fan of TCPA World, and I'm a super fan of his. The guy has really, we do a ton of advocacy at Reach, and he has been the guiding force actually behind a lot of the comments that we've done to the commission. He provides most of the data sets that you'll see, and those of you that pay very close attention to the docket, you'll see that Reach's material, the material that Reach puts together for the FCC in particular, is much richer than most agency or most advocacy groups when it comes to data sets and information. And John really provides most of that. All right, John, so let's get moving here. What do we got? Let's kick us off.
Well, let's kick off. So, yeah, so I've been tracking this one firm quite closely. They've filed nearly 300 quiet hours cases since November of 2024. And who knows how many pre-suit demands have gone out. Now, if you're not familiar with these cases, they're rooted in FCC regulations that state that no person shall initiate a telephone solicitation to any residential subscriber before 8 a.m. or after 9 p.m. Now, firms are exploiting this by alleging that this restriction applies to calls made with consent. And it's confusing because the regulations define a telephone solicitation as a call encouraging the purchase or rental of blah, 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 blah. But it explicitly excludes calls made with a person's prior express invitation or permission, or calls where there's an established business relationship. Unfortunately, this definition doesn't mention anything about prior express consent. So the plaintiffs are basically taking the position that the quiet hours apply to calls made with consent. They're just exploiting a poorly written regulation, unfortunately.
Well, it's not just that though, right, John? So you're right. To me, the regulation's not poorly written. To me, that's actually a very clear regulation, right? Quiet hours provisions apply to telephone solicitations. Telephone solicitations are by definition unsolicited communications.
Yeah,
Consented communications are not telephone solicitations, and therefore consented communications do not trigger quiet hours. What they're doing is exploiting essentially a factual anomaly, which is I have a cell phone, right? It's a 310 number. As you guys know, I travel all across the country, right? I'm on stages near and far. So when I'm in Florida, right, I'm 3 hours apart from where my normal time zone is. So if somebody wants to shoot me a text message at 6:15 my time, Pacific time, but I'm in Florida, it's 9:15, and they just violated the quiet hours, even though in theory, right, they were communicating with me at the right time for where they thought I was, which is on the West Coast. But because I travel, I'm on the East Coast. And you just see a ton of these examples, right? You've got guys on vacation in Europe and they're getting messages at 3:15 a.m. and they're suing for that, right? But obviously the business in America wasn't trying to contact them at 3:15 a.m. So you put together those two phenomena, one, which is that consented communications seemingly are not even subject to these rules, and so people think that they're safe to communicate outside of hours. But really, the larger issue is that they believe they are communicating within hours, but unbeknownst to them, this consumer is somewhere where they don't know where they are. And as a result, these quiet hours cases are going. And if you go to the next slide, John, I love this, right? This guy Hindi is so focused on this. He's got a massive marketing campaign, right? And he's one of these guys. I don't know. He's an interesting fellow. That's all I'm going to say. I don't want to pick on him too much. He's got some personal stuff, and I don't want to pick on him too much. But he's an interesting guy, right? He's a bodybuilder. He's got kind of a personal brand where he's out there really kind of hitting the social media game quite a bit. But he says some very interesting things. Like, so John, like break down this one because like if you just think about what the guy's saying,
yeah.
I'm not sure this is the smartest thing. It might be good to bring in cases, but I'm not sure this is really what he wants to be putting out there publicly when he's bringing these cases.
Yeah, no, exactly, and this is my motivation for sharing the statistics that I've compiled today, which, by the way, are all quiet hours cases, only filed by only his law firm. But I saw this ad on Facebook, and essentially, it's how do you get paid? Simple. After we file, we go straight to settlement. I mean, it's essentially an open admission that this has nothing to do with consumer protection, and it's all about extorting settlements. He basically said the quiet part out loud, no pun intended. But it motivated me to create this deck.
Pooja, feel free to jump in here at any point. I know you've got tons of feelings and thoughts around all of this, but cut us off anytime you want. All right, John, what do we got next?
So let's jump into the data. So, um, so we'll start with an analysis of these quiet hours complaints. I'd seen 287 cases filed through July 6th, the date that I assembled these graphs. Two more were filed yesterday, so now the total is 289, at least that I know of. Again, I want to make sure everybody knows that these are just quiet hours complaints, all filed by that single South Florida law firm.
And John, are all these text message cases as well?
I believe they are all text message cases, yeah. So the vast majority, I don't think there were too many that involved calls. It looked like they were all texts.
Yeah, I think it's just easier for him to track or at least send demands out is what I suspect because he has, the time that shows up on the text versus having to
Yeah, we can swing.
call recordings and whatnot. So that's another issue too, Eric, that I think we should talk about is, the text versus calls. So it's interesting that he's just in the filing for text messages specifically. So for, important for those folks who are specifically sending text versus calls.
Yeah, I mean, I think that's where we're kind of really calling out. It's a good point. I mean, really what he's looking at is text clubs, right? Like he's primarily targeting retailers to my eye. Companies that are trying to have regular engagement, usually with some kind of like a discount code or a coupon or an incentive to the consumer. There was a case, it's actually not one of these quiet hour cases, but I'll just use it as an example. CVS was just sued today by the Wolf, Anthony Peronic, so it's a different law firm, different theory, on an SMS campaign for their extra well care or whatever heck it is that they have as their text club, right? So it's these kinds of enrollment text clubs, particularly around retail, that people sign up for. And again, these communications are generally going out during the proper time frames, right? Based upon the zip code or the area code where that consumer is. But because of the mobility of cell phones, either the person doesn't live where the entity thinks that they live, or again, in my experience, more likely that consumer is just traveling, right? They're just not in the zip code or area code where they're supposed to be at the time the message is sent. So yeah, these are the kinds of cases that these folks are looking for. And again, for those of you that wonder, that one ad that you just saw, I mean, they've got a ton of these running. I mean, I don't know how many, it could be hundreds. And this is kind of their game, right? It's on TikTok, it's on Facebook, it's on the social media, convincing people. If you see these billboards, you see these ads, guys, it's basically like they're encouraging you, like you won a jackpot or a lottery or something, right? Like, hey, congratulations, you're gonna make $1 million. Like, how do we get this done? Give us a call. We'll get this thing filed, we'll get it settled for you. There's money in your pocket. You know what I mean? It's just like it's
Yeah.
just so scammy and non-professional in my opinion. But who am I to cast aspersions, right? People don't always like the way I do things either. So again, I'm trying not to pick on anybody, but just like the reality of the situation is they are coming to market with very slick, glossy ads, promising quick money, and basically just shaking people down for it, right? So back to the data here. What do we got, John?
So this is an alternate view of the previous graph. I like this one because it highlights that often multiple cases are filed per day, sometimes a half a dozen or more. And at their worst or at its peak, they filed a whopping 12 cases on March 11th alone. So they're just cranking these out, copy and
These are
paste.
class actions. These are classes. Every one of these is a class action, correct, John?
Yes, they are.
All right.
So, so it appears that nearly 170 of these cases have settled. And if you assume like 10K per settlement, that's 1.7 million in over just 7 months. And it's not too bad for a little copying and pasting. And again, these numbers don't include any pre-suit demands that they might be getting under the table.
John, the one thing I don't think you have in here is the average duration of one of these cases. But I mean, if you just kind of look at 170 out of 200 and whatever it was, so you're talking like 40,
Yeah, we're
40%,
about 60% have settled in under 7 months.
60%.
Yeah, so about
Yeah,
60%.
so I mean that's pretty remarkable, right? I mean these guys are they're burning and churning. Some are still out there. Obviously, the more recent ones are still out there, but basically all of the older ones have resolved, which is I mean just tells you exactly kind of what's going on, right? I mean you're talking about 60% of these cases are gone within 7 months.
Yeah, they're selling out within a couple months, and I could crunch the numbers on that. It's always the curse of data is that you start out with it when you start building the data set, you think, okay, I need this, and this. And then 3, 4 months in, you find out, oh, I didn't need point number 4, but I wish I would have added this data point. Uh, and I think this is fascinating that, for a South Florida law firm, they sure do file a lot in California. Nearly three-quarters of their cases, with half of the cases filed in the Central District of California alone. In fact, the two that were filed yesterday that aren't part of this graph were also filed in the Central District of California. So I guess that's why he needs that private jet.
It is interesting, and that is actually his private jet there. Is that right, John?
Yeah, it's from a
Pretty sure.
YouTube video where he posted himself about how he was able to buy this $10 million jet.
Yeah, that is interesting. Yeah, so you'll notice, that the California filings here, to me that's very telling, right? You are a Florida law firm looking for Florida clients but you're suing in California, right? What does that tell you? It tells you that a lot of the entities that are being sued have headquarters in California and are communicating with people on the East Coast, thinking, presumably, that they're communicating with people on the West Coast. As a result, the messages are going out too early, right? So that's why you're seeing this very, very skewed map here because of the exploitation of the essentially the trap that I'm in California. I think I'm talking to a California consumer, right? Maybe it's a California area code, but guess what? These people are actually in Florida. And as a result, when I send out a message that I think is going out at one time, right? It's actually going out, I guess I said earlier it'd be too early, but it's actually going out too late, right? I send a message out at 7 a.m. or 7 p.m. and really it's going to that person's phone at 10 p.m. And that's where you're seeing this skew. So to me, that's like not even surprising. Like this is what you would expect to see. You'd expect to see a Florida law firm with Florida clients suing massively disproportionately on the West Coast because of the exploitation of the time zones. And I mean, the real takeaway is those of you on the West Coast, I mean, you guys are targets here. I mean, plainly, if this slide tells you nothing else, California companies are targets for this person because they of this time zone exploitation trick. So if you're in California, you're on the West Coast, you got to be extremely careful. And that's true also in Texas. It's true also, right, in the central time zone, the mountain time zone, right? They are trying to trap you on these time zones. So you've got to be very, very cautious.
Then I thought it was also interesting to look at the timing of the filings. So I've got a couple graphs that I've broken out into years, and they show that 25% of the cases that have been filed are alleging texts were received a year or more before the claims were actually filed. So, and in the second graph, I highlighted the ones that were more than a year, and two of the cases actually cite texts that were sent 4 years prior to filing, like 3 years and 364 days. And that's kind of a chilling reminder of that 4-year statute of limitations that applies to the TCPA.
Yeah, and that is, this is the troubling thing, right? What you do today stays with you until July of 2029, folks, right? That is a long time from now. And you see all the ads that they're doing, but as you can tell, right, this is a theory that these guys kind of stumbled up into at some point late last year. And like I wasn't in the room when it happened, but you can almost imagine like the light bulb goes off and like, oh man, we should bring these cases. And as you can tell, because so many of these are over a year old, what does that mean? It means, like we often see in the SIPA world, is that these guys have their portfolio of consumers, right? All of whom have gotten free money in the past, all of whom want more free money in the future. And they go back to them and they're like, hey, we brought you a suit previously, we got you a claim for X, Y, and Z. How would you like to go back and make another claim this time for a quiet hour violation, right? And they see how many different text messages these people have received. And of course, they can bring these suits. And of course, you could also bring in a consumer brand new, right, who has records of their text messages going back years. But many times, right, when these plaintiffs' lawyers come up with a new theory, they just go back to the well, the same consumers they represented in the past. And you're going to see a slide on that here momentarily, and convince them to rebring these suits anew. But again, that 4-year statute of limitations, you just see it right there, right? Look at these cases, some of them from 4 years ago, 3 years ago, but the majority of them are between that 1 to 2 year mark.
No, exactly. And as you just mentioned, yeah, they do cycle through the same plaintiffs over and over. In the data that I have says 16 individuals are named plaintiffs in 3 or more of these quiet hour cases. Now, I don't know how many other cases that that the firm has used these folks as named plaintiffs, but here's the list of these 16, and so everybody can make sure that you add them to your internal do not call lists. I've added them to mine, and I've also uploaded them to the known litigator scrubs as well.
Once again, a slide that's worth its weight in gold. Great job, John.
Thank you, thank you. And they're targeting big and small companies alike. I don't quite have enough data yet for a case study, but here's an example of how this frivolous litigation risks putting people out of business. In King v. Clear and Strategic, a small business sole proprietor was sued. Unfortunately, due to financial hardship, the owner's been submitting his own filings to the court, and some of them have been rejected for non-compliance with the rules, because they weren't submitted by an attorney, and maybe this poor guy can't even afford an attorney. And if he can't afford a lawyer to defend himself, how is he going to afford any settlement? Pay sell his business to pay off the gangsters, declare bankruptcy. So it's kind of a sad story, and it's unfortunate that in the world of the TCPA, the deck is stacked against us. These plaintiff firms are, I don't know, this is maybe a stupid metaphor, but these plaintiff firms are like the sixth grader that punches the second grader in the nose and holds out his hand. It's like all you do is give him your lunch money. And this is why TCPA reform is so desperately needed.
Oh yeah, and these guys are bullies. I mean, there's just no question about it. And look, we've got some good relationships with some folks on the plaintiffs bar, right? Some of the guys I respect because they do things the right way, and they go after big companies that might actually have made a mistake. And look, the plaintiffs bar, they serve a purpose. They keep people in large companies in check and performing the way they're supposed to perform. And so I respect some of them, when they're doing things, that are basically pro society. But I mean, stuff like this is just so anti-societal, right? I mean, you're just trying to exploit a loophole to extract money off of some small business. Many times, like these are like a one-person shop, less than 10 employees. They're working hard. They're trying to have their dream, right? They're trying to communicate with consumers who want to be communicated with. These are, largely, not always, but largely these are opt-ins. These are consented. Like these are messages the consumer wants and expects. And because, one guy is traveling and wants to set up a lawsuit, if that's the case, I mean, this guy could go out of business. It's just a terrible thing. It's just so nasty. And that's why I wanted to have this webinar once I started seeing your data, John. It's just gross. I mean, it really is just gross. And I don't know what to say other than, we really need to have some legislators and regulators start paying attention to this. And through Reach's hard work with the commission, we're obviously going to bring this to their attention as well. This is an issue. It's something that needs to stop. And I know there was an FCC petition already against Hindi in particular. But when we kind of zoom out, we recognize that with the Hobbs Act being destroyed, which is a whole different issue, the FCC really has a lot less power now. And it's incumbent upon the courts to throw out these frivolous cases when they show up. But as we all know, right, you got one judge will look at this case and say, hey, that message shouldn't have been sent at 7:58 a.m., right? You'll have another judge that'll say, this is the most frivolous thing I've ever seen in my life. Get out of here, right? But the problem is you don't know what judge you're in front of. You don't know what the result's going to be until that hammer swings. And that's just a terrible situation. It's just terrible.
It really is. Yeah, it really is. And we talk about the cost of business, and I didn't put a slide for this, but it just reminded me that, to operate the courts costs money too. And who pays for that? We all do. That's taxpayer money. So, an hour of the court's time costs what, like on average, like $1,000. So every one of these lawsuits, when they consume the court's time, they're consuming taxpayer dollars. So they're leeching off society. Anyways, and then I wanted to shift gears a little bit and talk about one of the latest theories of liability. I've done an initial review of some of the cases that I've seen, of the cases that I have seen where people are saying stop without ever actually using the word stop. So now, unfortunately, the FCC did not define reasonable means for revoking consent. The rules only define a limited set of terms that constitute per se reasonable means: stop, quit, and revoke, opt out, cancel, and unsubscribe. However, the rules permit consumers to use other words and phrases, but there's no guidance for those other words and phrases. And by declining to define reasonable means, the FCC kind of threw us to the wolves.
So let's back up real quick, John. Let's remind everyone what the legal doctrine here is, right? So we all know the TCPA, Telephone Consumer Protection Act, says thou shalt not, right? Make unsolicited communications to phone numbers on the DNC, and thou shalt not use regulated technology to send messages to a cell phone without the appropriate level of consent. Once you have the right level of consent, either for DNC or regulated technology, right, that consent can go away. And this is the issue now that's being exploited, right? Under the TCPA, under common law, what the courts have found is that once that sender of that message knows that that consumer no longer wants to hear from them or has revoked their consent using clear and express language, then that business can no longer communicate, period, full stop. Well, in a recent ruling from April of, well, it became effective April of this year, the FCC clarified, right, and this is it's going to get interesting, again, with the application of the new McKesson Supreme Court case, what that clarification really means. But the FCC clarified that a consumer can revoke their consent in, quote, any reasonable means, and most importantly for everyone right now, in the SMS channel, it clarified that, looking here at paragraph 12, using the phrases stop, quit, end, revoke, opt out, cancel, or unsubscribe are per se reasonable means. But in in paragraph 13, it goes on to say, but that does not preclude the use of other words. Uh-oh, right? Uh-oh. So essentially what the FCC has said is that responding to an unwanted SMS message is per se a reasonable means of opting out, but the consumer does not have to just use these specific words in order to opt out. And this sets up a circumstance where you now have to be able to review your messages that you're receiving from consumers to objectively determine, right, is this person clearly asking to opt out or not? And they don't have to use specific keywords, right? That's the legal situation we find ourselves in. Because if we do not honor that revocation and we continue to message that consumer, we're violating potentially the DNC rules, violating potentially the regulated technology rules, and violating definitely the internal DNC rules. Okay, so very high stakes poker here. If we're making these outbound SMS attempts, particularly for marketing, again, thinking about text clubs, thinking about these retail brands that want to have engagement with their consumers, and if we can not detect a free form revocation that is clear, we're in trouble. Okay, so let's look at some examples.
So, and yeah, this is a relatively new phenomenon. So I've only seen 7 cases filed in the last couple months, but I do expect to see more. And here is how the supposed opt-outs were presented in the complaints, referred to as stop instructions that were ignored. In Hensley v. Total MMA Studios, no, and please don't contact me again. In Mockled v. Hannah Cars.
Yeah, let's pause. Let's pause. Let's go back to that last one. So again, you are on a jury. You're a judge. You see no, a plain response to the previous message. Please don't contact me again. Thank you. I gotta tell you, that's pretty freaking clear, right? That consumer, to my eye, as the judge, as somebody on the jury, says that consumer just revoked their consent. They did so clearly, right? They did so in a way that is reasonable, considering that the business communicated via text, so it's only reasonable the consumer respond via text. And the intention of that consumer requesting that we not be contacted again, I mean, it is as plain as day, right? Please don't contact me again. So to me, that's a valid opt-out. What's the problem? The problem is that this platform, right, whoever they were using, right, maybe they were using Twilio, whoever they were using, it did not pick up the fact that this was an opt-out because presumably the word stop wasn't used, exit, unsubscribe, cancel, something like that wasn't used, right? So you see right there, these are exactly the circumstances that are leading, that are currently leading and will lead to a massive number of lawsuits, which tells us right out of the gate, right? We've got to have a way to be ingesting revocations via SMS in a free form format. Because if a message like this comes in, we've got to be able to capture that.
I will say, Eric, I am shocked that, whatever platform they were using, or maybe they're relying on humans for to determine what's a reasonable opt-out. The fact that there's a no in there, I'm shocked because even companies who are relying on a large list of opt-out terms, right? I know some companies will they'll scrub it against those terms and they'll have a laundry list of different terms. Usually no is on that list. So I'm actually surprised that, this one got through on
But
whatever
there's a
using.
lot of businesses though, Pooja, that I mean, God, I can think of like within the last 365 days, I've talked to a business, obviously I cannot name them. I've talked to a business that was still only honoring perfect stops. STOP. It was the only thing that their system could pick up. That's madness, right? Like that you can't live that way. You're
Right.
right, Pooja. There are a lot of companies that have multiple now words or phrases. Um, and maybe you're right. Maybe this one should have had no on there. I don't know.
Well, because the reasonable standard has always been there, right? The FCC just kind of clarified and confirmed what was already being applied by the courts, right? That standard was already being applied. So I'm actually just quite shocked. Or maybe, they were just sort of following TCPA world. Who knows?
Yeah, and look, and that's the point of this webinar. It's really well said, Pooja, is really what the FCC did in April isn't new, right? I mean, this has really kind of already been the law. But what they did was just kind of make it absolutely crystal clear, right? Particularly that you can't just rely on these key words, these few key words. Because there was some folks, I think, that thought, well, hey, I'm honoring, 5, 10, 15, 20 key words. That's reasonable, right? And they figured, hey, this is a defensible position. The commission just came out and basically said, no, it's not, right? So that's the change. But really, you're right, Pooja. I mean, this always should have been picked up. But it remains the fact that I'd say probably 60 to 70% of enterprise out there could not pick up the phrase, please don't contact me again. Thank you. I just, unless you have a manual or a, fuzzy scrub, and we know there's a couple of vendors out there that have, really good disqualification indicator technology where they can pick that stuff up and it can be an overlay for your existing system. Like, unless you have something like that, if you're just relying on your technology vendor, like your SMS vendor to pick this stuff up, very high likelihood they're not going to. So you've got to have an alternate plan, and that could include flags, it could include manual reviews. Really, it should include some form of AI, in my opinion. This is you guys know I'm very anti-AI in the practice of law, but this is a good example of a place where AI can be trained to pick up the indicators and intent, which is really what's going to be driving the outcomes here.
I'll be remiss if I don't add this. A few of recently the compliance projects I've been working on are helping folks with the revocation, standards with the TCPA. A lot of folks are relying on just Twilio's interpretation of a stop work,
Yes.
right? And that is not enough, folks, right? You cannot just, I have so many folks who get on the phone with me and tell me, well, Twilio's processing our revocation. Not enough. And these examples are a reason why.
Exactly, and that's why I track these cases so I can go, is this on our list? Is this on our list? Is this on our list?
And that's great, John. I mean, and here, just to make sure everyone understands what John just said, John is the director of compliance at Americor. He is reviewing all these cases by hand so that he makes sure that there's no gaps in his company's system so that he doesn't fall and his company doesn't fall victim to this, right? I love that. Now, not every institution is going to have a John Barbret, right? Because he's a very special guy. But you do need to have something in your bailiwick here to detect these things and root them out.
Absolutely. So, and then, yeah, moving along, let's see. So Hensley v. Total MMA Studios, there was a no. And then in Moclid v. Hannah Cars, just no. And
Yeah,
then,
let's stop here real quick. And Pooja, you would agree with this, right? Because of the common law standard that looks at the subjective knowledge, right? What the caller knew or should have known. If the question is, "Hi, Gene, are you still interested in the car?" and they say no, right? This is going to create some tension, right? Because there is some case law that says I'm not interested is not a revocation. There's case law that says that you have to have express language indicating that you don't want to be contacted again. On the other hand, right, again, common law says that consumer it can't be contacted if the business knew or should have known that they've revoked their consent. So there's a little bit of tension there, right? What do you think, Pooja? A no in response to hygiene, are you still interested in the car? Is that going to be a valid revocation? Is that a valid internal DNC?
So putting myself as like the jury or right, it depends. Were you reaching out to this consumer only to sell that one vehicle? Right? If you were only looking to sell that one car and that consumer said, I'm not interested in that car, there's no other reason to call or text that individual because you guys were only discussing one car in the car, right? So again, you have to look to the background of, what was that company's operations, right? What products and services were they selling? Now, if Jean had signed up to receive options for multiple vehicles, right, and she was just not interested in that one car, then presumably maybe not interested. I'm just not interested in that one vehicle, but please continue to show me other cars, right? So again, it depends, and there's going to be multiple factors that folks are going to, consider. And unfortunately, at this time, if you are getting that deep into litigation, you're already exhausting resources, litigation costs to fight something that probably should have just been processed as a revocation to begin with.
Good stuff, Pooja. What's next, John?
And next is Gabai v. Tab Labs. And they texted remove and no. And
There you
that's
go.
3 no's in a row. Almost seems like somebody might be coaching them on how to be evasive.
Well, that word remove, I mean, there you go, right? I mean, to me, that is a classic trap word because remove works great for email lists, right? But nobody uses the word remove in an SMS, right? We all know that stop, maybe unsubscribe, maybe quit, right? We know that that is the way to stop communications on a text. Like we all know that. So somebody typing remove, to me, this has the hallmarks of someone who is intentionally trying to trap a business. So obviously you'd want to add that word remove to your list because to me that one's a big red flag. This one feels like if I'm the judge, I'm like, wait a second, this is a trap, right? What do you think, Pooja? Do you agree with that?
Yeah, if they probably.
But maybe
Um,
not. You seem a little less convinced.
I would consider that a clear opt-out.
Well, there you go. Right? I mean, that's what I'm saying. Like the word does indicate opt out. I don't think there's any doubt about that. To me, it's like the intention of the person typing in remove is not really to be removed. The intention is hoping that this will continue so that they can be sued. That to me, this is setting up a lawsuit. But maybe I'm wrong.
I think if it was, I could agree with you if it just said remove, but I can see, say my mom, right? She just types stuff like take me off or remove no, right? In conjunction with the no, I feel like that individual, and again, I probably want to depose that individual, right? If that it depends on who's also sending the text message, right? Who's that inbound text message coming from? So again, there's so many factors that come into play. And then I'd also want to look at, did this individual actually sign up to receive tab chocolates? And when did they sign up to receive tab chocolates? And were they on the search for chocolates at the time, right? Is it an individual who doesn't even eat chocolates? I don't know. It's just so circumstantial that I would need to know more facts, Eric, in order to just assume that this individual is a serial litigator looking for a TCPA lawsuit.
I will say, another data point to you, and this is something that John, we need to be very careful with, is look at the call to action here at the end. It says, or just reply
Yeah.
yes. So responding no does seem to be kind of an enhanced revocation effort in response to a call to action that says reply yes. You say no. I mean, that does kind of indicate, right? So I don't like that word remove. That word remove to me seems like you're trying to set up a lawsuit. But that word no in response to a just reply yes, Pooja, maybe I'm in your camp. Maybe I'm like, wait a second. No, these messages should have stopped, given the context, right, of that communication, that CTA.
See, when I read this, though, I see, if you want to buy some chocolate, reply yes. I reply no means I don't want to buy chocolate. And I think this is a microcosm of the situation that we're going to be facing is that there's
Yep.
what, 100 federal districts, and you're going to have 100 different opinions on what works. What's a scam in one jurisdiction might be, valid in the next jurisdiction.
Thank you, Supreme Court, for throwing out the Hobbs Act, everybody. Okay, what's next?
Next is uh, Tory v. American First Finance. I think you blogged about this one, Eric, as well as we discussed this one in Reach meetings. The cease and desist all communications. That's, if you don't have that keyword in there, you might not have thought of it before, but you better get it in there now. So,
Yeah, to me, this is the classic one that people just have to be watch out for, right? Cease and desist all communication. Again, if I'm going to judge or a jury, this is plainly a valid revocation, right? Like you cannot get clearer than this. Now, you can question what is the legal impact of this statement, right? Cease and desist all communication. Do they have to stop emails? Do they have to stop letters, right? That is a different question. The question presented for this topic is from a TCPA perspective, is this sufficient to revoke consent? And the answer is yes. And the answer is across multiple channels, right? Like you could not make outbound robocalls to this consumer after the cease and desist all communication request, in my opinion. And again, if you're not monitoring these SMS channels, like I said, I can think of businesses off the top of my head that would not pick this up and would keep calling and texting after a cease and desist all communication. And man, you are just begging for a lawsuit at that point.
Yeah, this one is, this one's alarming, especially in the email space. I understand, under CAN-SPAM, you don't require right of action, but states do have, laws governing telemarketing emails. And so, the response here says you're unsubscribed, looks like to all SMS alerts. I'm curious if American First Finance was also sending emails to this individual, because that response says we're only going to stop SMS alerts. So if I'm putting myself in the shoes of the plaintiff or the recipient here, I'd want confirmation also that it's going to be more than just SMS if they're sending more than SMS alerts.
Yeah, I think in this case they kept sending SMS messages anyway. But if they were calling, you're definitely asking for trouble. And you're right. Even emails, there's not that many states that would allow a direct claim, but some will. But yeah, those phone calls have to stop as well, not just the text messages for sure.
and that's hard, that cross-channel opt-out. Supposed to be stayed, right?
Well, and that's the other thing, right? Is the cross-channel opt-out on a standard stop, right? Let's say instead of cease and desist all communication, it just said stop. Pretty clear under today's law that that stop would only pertain to the text channel and probably only pertains to the specific purpose for which that message was sent, right? So if you've got multiple touches with that consumer, different business units making outbound attempts via text for different purposes, a stop to one today probably does not impact other channels and probably does not impact other business units or purposes. Once the new rule from the FCC becomes final in April of next year, remember it was supposed to be April this year, but through the efforts of some trade organizations like the ABA and the NBA, it got moved back a year to April of next year. Once that ruling becomes effective, if it is enforced by the courts, then a stop would result in you having to stop all messages to that consumer across all business units for all purposes, across all channels for which the same level of consent or higher is required. And I'm not going to spend too much time on that right now on this because this is not the purpose of this webinar. If you need more information on that, just go to our YouTube channel. We've got a bunch of SMS messages on that, or you could Google or of course search TCPA World. I guess we have a bunch of SMS messages on that. We have a bunch of videos on that. I think I misspoke. In any event, there's a lot of content available for you on TCPA World and on the Troutman and Amin YouTube channel, kind of breaking down the nuances of the new rule, which will go into effect in April of next year. But again, because of the Hobbs Act being thrown out, it's not clear how much impact that ruling is even going to have. But the bottom line is, even today, right, stop is one thing, but cease and desist all communication is something else, right? Even today, without that cross opt-out rule in effect, you have to honor a cease and desist all communication when it's received from a consumer. You've got to have the ability to cross-pollinate that, right? This person didn't say stop. They said cease and desist all communication. And again, from a revocation of consent standpoint, this is probably going to be sufficient for that judge or that jury to say, when those phone calls continue or when those messages continue for other purposes, I mean, the guy was clear. You shouldn't have sent those messages. So something to think about.
Then next is Gomez v. Gage Bowl. This is quite creative. Exit.
Well, see, what's interesting on this one though, John, is you'll notice that
exit, yeah.
that's what they invited that, right? And
Yeah.
so this is what gets interesting, right? Is every once in a while you'll have a campaign, and people do this for different reasons, right? Like for instance, many people will be operating on a system where if they reply stop, then for instance, it's a nuclear opt-out, right? They will stop across all channels or all SMS channels for all purposes, and the business doesn't want to do that. So they create tailored, opt-out opportunities for specific campaigns. It looks like that's what happened here, right? Come join the fun, reply exit to quit. Now, again, responding exit in isolation without that call to action or without that opt-out notification, I would say that is bullshit. This guy's trying to set up the lawsuit, right? But in this context, I think that this person followed instructions, right? And was doing what they should have done in order to exit the campaign. But what happened, right? It wasn't properly absorbed by the platform. Now, I don't know why that is, right? I have no idea. But factually, if the allegations of the complaint are true, the guy responded exit per the request of the opt-out and just kept right on getting messages.
Or like you said, they're running multiple programs, and so they opted him out of one program, but then when he got the next text for a different program, just claiming
Yeah, we work with enterprise all the time, right? To try to come up with strategies to not excessively disqualify people from campaigns, but also to honor consumer consent and content preferences. And so, you do see this sometimes, people wanting to curate essentially an opt-out mechanism only for a specific campaign. But to your point, John, it can sometimes be very difficult, especially if the messages are all coming from the same short code, to even disambiguate, right? As a viewer, well, when you said exit, like what did they exit? What did they not exit, right? And as a consumer, you might not fully even understand what that multiple campaigns, multiple uses, multiple business units are communicating with you via the same shortcode. So that is a very significant thing to keep in mind. If you're going to collapse your business units and outreach into a single shortcode, you really don't have the opportunity at that point to curate and opt out for a specific campaign. If you're using multiple 10 DLCs or multiple shortcodes, you're going to have a little bit more flexibility there, right? Just something to think about.
absolutely. And then this next one is a similar situation where they replied just S, but there was an instruction to follow the S. So
I mean, again, S in isolation, probably not a valid opt-out. But I mean, look, they've gone and invited that, right? Text Y to continue or S to opt out. I mean, that's what it says. So when that consumer responds S, I mean, that's pretty reasonable. It's pretty on the nose. And again, this is an example, I think. I mean, this might be something else. You know what this might be is them trying to keep it under 160 characters, right? And stop would have been too long. Maybe. I don't know. I'm making that up. I don't know that. But it does make you wonder why they would create an opt-out mechanism of just the letter S. But it is what it is. Pooja, what do you think on this, by the way, these curated opt-outs? I know you work with enterprise as well. Kind of what are your thoughts on that?
I think they can be extremely helpful, but you have to understand and keep in mind that that's not going to be the only way the consumer can opt out, right? So if you are setting it up to make it easier on your end to process the the stops, an S, if I still say stop, that should still be processed as a revocation, right? So I think they can help in certain instances. I do agree they can help with the character limits, Eric. And sometimes it can give, the recipient an easier way to understand what's going to become a stop, right? You're actually making it friendlier and easier for the recipient to to opt out. But you really have to keep in mind that that's not going to be the only way the recipient can opt out. And I think that's where a lot of companies get, in a lot of trouble where, well, I told them this is how to opt out, and they entered a different text message, well, it's too bad. You're still going to be liable under the TCPA if you don't process that revocation.
Well, and also with curated stops, I've heard you say a lot of times that you have to make sure to communicate to the consumer what that curated stop means. So for instance, if exit just means reply exit to stop receiving messages about, X versus reply stop to stop all. So, and that's the other kind of piece, right, to the puzzle is when you're trying to curate your opt-out, you've got to make sure the consumer understands what it is that exit means. Because if exit means only that they're going to stop receiving alerts regarding ATM notifications, but they will still receive low balance notifications, you kind of got to make sure the consumer knows that. Again, especially if it's come from the same short code. Otherwise, that consumer says exit, they think they're done, right? Maybe they think they're done, and they keep getting messages about other topics, and they don't even know, right, that that was not what was expected. I know, Pooja, I've heard you give that advice before. So,
Yeah,
um,
so if you're not going to clarify what exit actually means, then you want to be overly inclusive and just opt them out of everything, right? And if that's where you're headed, then that's okay too. Because I know a lot of companies are just, I don't want to deal with the different points of revocation or the insertions. I just want to opt them out and be overly inclusive. So I think the curated messages without the clarification is fine, so long as you plan on opting that recipient out of everything. Otherwise, yes, Eric, I agree. You have to make it clear to the consumer what it's going to mean when they respond with that certain keyword.
all right, what else we got, John?
And we saved the best for last.
Very good.
The incredibly verbose. I do not wish to be contacted. A whopping
Fantastic.
29 characters, over 7 times as many characters as it would take to just type stop.
I mean, plainly, this is an opt-out evader, right? Plainly, this is a classic example of somebody who's looking to, he's not trying to have the messages stop. He's trying to have the messages continue in a way that he can sue for. And that's what he's done. So, again, it just goes back to it. These are predatory lawsuits. You cannot let yourself be the victim. You've got to be looking out for this stuff. On the topic of predatory lawsuits, and thank you, John. That's all of our content from the
And I just had a
PowerPoint.
couple,
Oh, you got something else? Go ahead.
just a couple more if we want to. We don't have to. The cases are fairly new, so there's not much of a record that's been developed yet. But to date, we are seeing the same patterns as in the quiet hours cases. For example, sloppy filings. They're not filling out their templates completely or correctly. I've also seen a couple of quiet hours complaints stating texts were sent from the future. Uh, and we're also seeing a lag of over a year between the receipt of the text and the filings of the claims. Text sent long before the new revocation went into effect. And for the purposes of this chart, I just assume that Gomez v. Gagebowl, where the texts were sent in December of 2024, not 2025 like it is in the complaint. And then we're also seeing many of the complaints include claims for texts that were sent within 10 business days, which shouldn't be a violation. But again, our friends at the FCC decided 10 business days was maximum, not a minimum. So every delay can subject you to risk. And then again, it's early on,
That's a
but
really good point. Hang on, let's pause. Go back to that last slide, John. That's great for people. Another trap, right? We've got 10 business days. We feel pretty confident. Look at this, 2 days, 1 day, 8 days, and they still got sued. Now, maybe they're going to be able to defend that lawsuit based upon the reasonable timeframes, but just keep it in mind. You might still get sued if you're not immediately honoring a valid revocation.
and then the last one is it's early on, but they do seem to be favoring California again. So, and the settlements have begun. In Hensley v. Total MMA Studios, a voluntary dismissal was filed without the defendant ever filing, and in Moakland v. Hannah Cars, a notice of settlement was just filed yesterday without any answer to the complaint. And both of those were cases where no was used as the opt-out. But just this is all just TCPA reform is so desperately needed.
Yeah, and so let's get to a couple of points here. Somebody had a really good point in the question and answer. If you guys have any questions, we got 5 minutes. We'll get through these as many as we can. So stick some more in there if you want. Basically somebody said, Spencer asked, are they just banking on defendants just settling? Based on your earlier comments, isn't it easy to beat the time restriction claims where there are consented to calls and not unsolicited calls? I mean, the answer is yes. And that was like the stunning admission, right? Saying the quiet part out loud in the Facebook ad that we looked at in the beginning. These guys have no intention of going all the way. The problem is, right, and this is why we have this webinar to raise awareness, right? If you're a TCPA defendant and you can get out of the case for $7,500, and my true retainer is $6,300, right? And you spend 30 minutes of my time and now you're over $7,500 total. I mean, just think about that, right? I mean, I love a company that will fight. We had George from Alleviate Tax on our podcast a while back. I wanted to highlight him because he's the fighter, right? These are guys that they spend six figures, right, with us when they could settle a case for maybe four figures, but they do it so that they are not the victim of future cases and to put a stop to antics like these. Right. But unfortunately, there's not very many guys like George out there because arguably, really, he's irrational, right? The purpose of business is to make money. It's not to change society in some way. He's one of these guys that's like, no, I've had enough and I'm going to fight hard for society and put a stop to this stuff. But 99% of businesses are the opposite, right? 99% of businesses will write that check for 10K, 15K because it's a multiple cheaper than litigating. And that's just a fact. It's just a fact. And the other side knows that. This guy right here on his little video, he knows that. And honestly, guys like Peronic, guys that file really, more meritorious cases most of the time, they know that too. And they're not looking for 10K or 15K, right? They're looking for 60, 70, 80, 100, 150K, maybe more, depending on the lawsuit, because they know that's how much it's going to cost enterprise to defend class litigation to a certain stage in the case, right? It's all calculated on their part, on the plaintiff side, to get the maximum number of dollars that they possibly can get out of you, given the nature of the case, the jurisdiction, the court, the judge, and what kind of case it is. So the simple answer to your question is, Spencer, they are absolutely banking on settlement. And unfortunately, they are almost always right because very few companies will push them. And that's just a fact. What other questions do we have here? Let's take a look. That was a really good one. Always appreciate you as always. Statute of limitations on some can opt out. Example, text message sent January 2025. Is there ever a point when we can stop looking for opt-outs for that campaign, or will a stop come back to haunt you years down the road? What's the rule, Puja? It's 5 years, right? Yeah, I think it's 5 years. I think Puja's gone on to something else. We got another call here at the top of the hour. Let's see what else we have. Have you experienced situations where the customer does respond stop to a text message but sends it from a blocked number so that the stop response cannot be attributed to their phone number? Thus, the text continue. I've actually not seen that. Have you seen that, John? That's interesting.
I've not heard of that, but that is smart. So I know that a lot of these folks are starting to use like Google Voice numbers so that they can snowshoe and generate claims at multiple numbers, whether they're text or calls. But I hadn't heard of sending stop from a blocked number.
It's interesting. All right, folks, we're right at time. We appreciate all of you for showing up. Bottom line here is that, these lawsuits continue to pour in. You've got to protect yourself. Yes, these are shakedown lawsuits in most cases. Yes, this is scumbaggery, right? But we can't just sit around and whine about it, right? We've got to be smart. We've got to protect ourselves. We've got to get good counsel, have good practices. And obviously, Reach is going to keep doing what Reach does and reach out to the FCC, no pun intended, and try to get these facts, these hard data points in front of decision makers so we can do something to stem the tide. Puja, any last thoughts?
Just keep in mind, right, you have the federal time restrictions, but you also have states that have some more restrictive time, quiet hours. So keep in mind the state laws as well.
John, any last thoughts?
Yeah, it's just don't think about things in terms of being compliant, because TCPA compliant businesses get sued every day. You need to have active defenses so you can try to stay a step ahead of the litigators, and that means implementing the right tools that'll help you identify these folks so that they never get never get added to your systems or put in your dialer, and doing your own homework and don't just follow the blogs like TCPA world, read the orders and the motions and the exhibits, because then you'll know exactly what the judge saw in reaching his ruling, and it provides you with data-driven real-world advice on strategies that you can implement. And then
All
lastly,
right, good stuff. Oh, go ahead, John. Sorry, finish up.
I was going to say, lastly, get involved. Work with your government relations teams to comment on proposed state and federal laws and regulations that will impact your consumer contact campaigns. Participate in industry action groups like REACH that advocate for TCPA reform, and comment on those petitions.
All right. Well, we love you guys. We'll see you in a couple days at Law Conference of Champions. Thanks for being here. Bye.
Hey, John. Bye.